This video will be going over the pretrial processes of a criminal proceeding. This video was prepared with the assistance of PBSC University of Manitoba law student volunteers. PBSC volunteers are not lawyers and are not authorized to provide legal advice. This video contains general discussion of certain legal and related issues only. If you require legal advice, please consult with a lawyer. We will cover the arrest and laying of the charge, judicial interim release and sureties, election, preliminary hearings, and plea bargaining. After the police make an arrest, they have two options. 1, they can release the individual who has provided notice as to when and where they'll be required to attend court, or 2, they may be held in jail pending a bail hearing, which would determine if they should be released or held until their trial. The laying of the charge occurs if the police believe on reasonable grounds that a person has committed a crime. The police complete an information package which describes the evidence, and a copy is then provided both to the Crown Attorney as well as the accused or their lawyer. Judicial interim release is also called bail. It involves the release of the accused from custody pending their trial. The onus or responsibility is generally on the Crown to show why an accused should be held in custody. The decision is made by a judge at a bail hearing, and there are 3 reasons that a judge can deny bail. First, if it is necessary to ensure that the accused will show up to their future court dates. Second, if it is necessary for the protection of the public at large. And the last ground is if it is necessary to maintain confidence in the administration of justice. This last ground is less common than the first 2, and the judge considers things like the strength of the prosecution's case, how serious the offense is, the circumstances surrounding the offense, and the potential for a lengthy prison term. If none of these 3 reasons are present, the individual will be released on bail. There are 4 forms of release, which occur either upon arrest or after the bail hearing. First is an appearance notice, which can be issued by a peace officer, and it is a notice that includes an address, date, and time for a court appearance. An appearance notice has no conditions attached. Next is a summons, which is issued by a judge when a peace officer applies for it. It occurs when the person was arrested and then released with no paperwork, and then later on the peace officer goes to a judge to make a case for issuing the summons to the person. Like an appearance notice, it contains an address, date, and time of the court appearance and has no conditions attached. An appearance notice and a summons are both provided when it is the police who release the individual. The third form of release is an undertaking. It contains the same court appearance information as a summons or appearance notice, but it also includes conditions to be followed upon release. These conditions may include keeping the peace and being of good behavior, having no communication with specified people, or abstaining from drugs and alcohol. An undertaking is usually entered into and given to a police officer following arrest, but it can also be issued by a judge as a form of release after bail is granted. Lastly, a recognizance is entered into before a judge after bail has been granted. Like an undertaking, it includes conditions to be followed, and it also requires a cash amount that the court can pursue if the person breaches any of their conditions. When an individual is released on bail, sometimes the court may also require a surety. So what is a surety? A surety is an individual who guarantees that the accused will appear for their future court dates and that the accused will follow the conditions imposed upon their release. Sometimes a surety is also required to post a dollar amount as security. Becoming a surety is not something to take lightly. It is a serious commitment. A surety is required to sign a document stating that they will pay a certain amount of money if the accused fails to obey conditions or to appear in court. When considering if you should become a surety, consider if you are sure that you will be able to supervise the accused until trial. Once you commit to becoming a surety, the obligation lasts until the accused has been acquitted, meaning they were found not guilty, or both found guilty and sentenced. Becoming a surety requires an application, and a justice of the peace will consider your relationship to the accused, background, and financial situation. To be a surety, you should live in the same community so you can ensure the accused's release conditions are met, not have a criminal record, not be a victim or witness in the case against the person. You must not be facing criminal charges or be a surety for another person, and must be able to prove that you can pay the amount required if the accused breaches their conditions. If you are no longer able or willing to be a surety, there are two options available. 1. You can bring the accused to court and ask to be relieved of your responsibilities. Or 2. You can go to the court office and apply in writing to be relieved of your responsibilities. The court will then order the accused to be arrested, at which time your obligations have ended. The Criminal Code of Canada divides offenses into 3 categories. Summary offenses are the least serious crimes, and accordingly, the maximum penalties are imprisonment for 2 years less a day and or a fine of $5,000. Summary offenses are tried at the provincial court level, and they are tried by a judge alone, meaning there's no jury involved. Summary offenses include making a false statement, causing a disturbance, and trespassing at night. Indictable offenses are more serious and complex. They include offenses such as first and second-degree murder and aggravated assault. Hybrid offenses are dual offenses. This means that they can be tried as either summary or indictable. The decision on which way to proceed is decided by the Crown. A majority of offenses fall within this category, such as unlawfully carrying a concealed weapon, assault, and theft under $5,000. For indictable offenses, or hybrid offenses where the Crown proceeds by way of indictment, the accused is entitled to election. They can choose to be tried in the provincial court by judge alone, or in the Court of Queen's Bench, either by judge alone or judge and jury. However, there are also some offenses that are absolute jurisdiction offenses, meaning that there is a specified court that must hear the matter. For example, the provincial court must hear breach of probation matters. This means that even if the Crown proceeds by indictment, the hearing will be held in front of a provincial court judge. A preliminary hearing, or preliminary inquiry, is a hearing held prior to trial to determine whether there is enough evidence to go to trial. A preliminary hearing is not a guaranteed right for all offenses. It can only occur if you have been charged with an indictable offense, or a hybrid offense where the Crown proceeds by way of indictment, where there is a potential sentence of 14 years or more, and where the accused has elected to have trial at the Court of Queen's Bench level. A preliminary hearing is available for serious offenses, such as murder and aggravated assault. It also must be requested by either the accused or the Crown. If neither party requests the hearing, the matter will proceed to trial. Upon a review of the evidence, the inquiry comes to an end, and the judge has to make a decision. Either there is enough evidence to bring the matter to trial, or there is not enough evidence and the accused is discharged. It is more common that the matter will proceed to trial because at this stage the Crown does not need to prove guilt beyond a reasonable doubt. They only need to show that there is some evidence which can be admitted at trial that could be used to find the accused guilty. In Canada, a majority of criminal charges are dealt with through guilty pleas, and therefore do not proceed to the trial stage. Plea bargaining includes a broad range of actions that may occur among actors in the criminal court system. The Crown and the defense can have discussions and negotiations which may turn into an agreement. A plea agreement is an agreement by the accused to plead guilty, and in return the Crown will agree to do or not do something. There are 3 categories of promises that may be offered to an accused. First, charge bargaining, which means reducing the charge to a lesser but included offense, or a state of other charges. Second is sentence bargaining, which provides for 3 possibilities: the Crown proceeding summarily rather than by indictment, the Crown promising to make a specific sentencing recommendation, or the Crown promises to submit a joint sentencing submission. Thirdly is fact bargaining. This is promising not to mention certain circumstances that may be interpreted as aggravating factors. Of course, participating in plea bargaining does not mean that the parties must come to an agreement, and the issue may still proceed to trial. Avoiding unnecessary litigation, time efficiency, and the private nature of plea bargaining rather than a trial in open court are a few of the benefits of plea bargaining. For more information on the topics discussed in this video, please see the resources listed on the slide. Thanks for watching.